To this, you sort of take the pre-claim situation, which is why I wanted the employment setting in, and you get into the actual filing of the claim. And then you get to the actual disputed claims.
Now that we've spent a little time on the medical side of things, we're going to try to turn to some of the legal issues of chronic pain, chronic fatigue, and fibromyalgia. And specifically in this section, we're going to try to deal with some of the issues that arise in the workplace when an individual is afflicted with one of these conditions. We have with us today Brenda Bowlby and David Wright. Brenda got her LLB from the University of Western Ontario, and she also attained an LLM in London, England in 1981. She currently works at Hicks Morley and acts on behalf of employers in negotiations, arbitrations, human rights boards of inquiry, employment standards tribunals, and wrongful dismissal and other court actions, including charter litigation. She's the co-author of a book entitled Employment Contracts: An Employer's Guide. David Wright received his LLB from the University of Toronto in 1986 and was called to the bar in 1988. He's a partner with the firm of Ryder, Wright, Blair & Doyle, and he practices in the area of union and employee side labor and employment law, including grievance arbitration, labor board hearings, wrongful dismissal actions, human rights complaints, benefits litigation, workplace safety and insurance disputes, and employment standards complaints, as well as professional discipline and judicial review. He's also a co-author of several textbooks in the area of employment law. So I'll turn it over to Brenda.
Thanks. David and I have been asked to speak on the issue of litigating and defending chronic fatigue and pain-related cases in the workplace. For the most part, litigation involving employees with chronic fatigue and syndrome and fibromyalgia will arise when these employees are dismissed from employment, usually for absenteeism reasons. Now, the nature of the litigation that is undertaken will stem largely from the nature of the relationship between the employer and the employee, and in particular, whether or not the employee is in a bargaining unit. Now, we've been asked to touch on a number of points, and David is going to begin by addressing the differences between unionized and non-unionized environments, and the issue of security of tenure, which will play a role in determining the nature of the type of litigation which might arise in an employment context.
Thank you. The nature of litigation of a pain-related case in the workplace depends largely on whether or not the employee is unionized or not, whether the employee is in a bargaining unit or not. That is the fundamental question that you really need to start by looking at and addressing. The answer to that question, is the employee unionized or not, has a fundamental impact not only on the substantive rights of the employee, but it also determines the parties to the dispute and the forum in which litigation has to be conducted. The key difference in a unionized versus the non-unionized workplace is a change in parties. The introduction of the union into the mix as a full party. In fact, in many respects, the union has greater rights than the individual employee. And there's also the change in forum, that when you're dealing with rights arising in a unionized workplace under collective agreements, litigation takes place in the context of grievance arbitration, not in the civil proceedings in the courts. A non-unionized employee is governed by an individual contract of employment, whether written or not, and the individual employee has carriage over civil proceedings in the court to enforce his or her rights. Bringing, for example, in the context of a pain-related case, bringing a wrongful dismissal proceeding seeking damages for having been improperly dismissed in violation, among other things, of the Human Rights Code can be brought. Alternatively, the non-unionized employee can bring a complaint to the Ontario Human Rights Commission under the Human Rights Code. And you should know, though, that in that scenario, while there's some different rights, the commission actually has carriage of the case, not the individual employee. However, when you're dealing with a unionized employee, I said earlier, the fundamental change is you have the union on the scene and in the mix as a full party. In the unionized setting, the contract of employment is not any individual contract, it's the collective agreement. And the union is the party to the collective agreement with the employer, not the individual employee or employees. The union, under the terms of the Labor Relations Act, is the exclusive bargaining agent for all the employees falling within the bargaining unit. And it negotiates, administers, and defends the collective agreement. There's no room for individual contracts of employment, and it's illegal, improper, for a unionized employer to deal and bargain directly with an individual employee to establish terms and conditions of employment. And even in the context of a litigation, a pain-related case, to deal directly with the employee or his or her counsel. Any discussions, any negotiations respecting the employment rights of the chronic pain employee have to be conducted either with the union or at least with the consent and knowledge of the union. The union may not wish to participate or may, want to participate at a different or later stage, but it's important for an employer to recognize that they can't strike an agreement to have reduced duties, reduced hours, reduced pay for the employee who needs accommodation without involving, consulting the union. It's also important to note that the union has obligations not just to the individual employee suffering from a chronic pain condition, and I use that term to cover any of fibromyalgia, chronic fatigue, chronic pain generally, but has the duty to consider the interests of all of the members of the bargaining unit that it represents. It has to consider and balance the interests of the individual employee with the interests of all the other employees. And this may lead the union to refuse to consent to an arrangement that the employer would be happy with and the individual employee wants, because it's of the view that that arrangement would not be in the best interest of its membership as a whole. So, for example, an arrangement whereby a person suffering from a chronic pain condition is removed from one set of duties and put onto an easier, lighter set of duties may be rejected by the union because of the interests of other employees in doing those duties and the seniority rights that may attach to bidding for those duties. That being said, the union is bound by the Human Rights Code as well, and a union that refuses to properly consider, properly weigh the rights of the individual employee can be found liable under the Human Rights Code. It has happened. The union is also bound by a duty of fair representation under the Labor Relations Act, which requires the union not to act in a manner which is arbitrary, discriminatory, or in bad faith towards any of the persons that it represents in the bargaining unit. So there are limits on the rights of the union, but at the same time the union does have the legitimate right to say, while this might be good for employee X, it is not good as a whole, and therefore we're not agreeing to it. If issues can't be resolved in the unionized setting, and there's to be litigation, the litigation takes place, as I said earlier, at the initiation and prosecution of the union, conducted in accordance with the grievance arbitration provisions in the collective agreement. The union is the party to the collective agreement. The union's the plaintiff, as it were, in that setting. And it's the union that decides whether or not to launch proceedings, again, subject to its duty of fair representation. It's also important to note that when you're under a collective bargaining situation, there is really no recourse to the courts, except when you have a judicial review of the arbitration decision, which we've just told the standard on has changed, but basically arbitration decisions are given a great deal of deference by the courts even in that scenario. The Labor Relations Act provides that all disputes respecting the interpretation, administration, application of a collective agreement have to be referred to final and binding arbitration. There's a couple of key Supreme Court of Canada decisions in this field which really make it, taken together, make it very clear that in the context of a unionized employee and a pain-related litigation, there is no room for recourse to the courts. The first is the Weber case, which has adopted an exclusive jurisdiction model and says that where the matter rises out of the collective agreement, it's got to be taken up through litigation. And as I said in the paper, the facts of that case show that the court is taking a very broad interpretation of something arising out of the collective agreement. I've given you a reference. I mean, the discussion of the precise parameters of what the Weber case involves is far beyond the scope of a discussion here, but there's a reference to quite a good paper by arbitrator Michael Pichet in the material that if you want to follow it up, that would be a place to look. The other recent case last year of the Supreme Court is the Perry Sound decision. It dealt with a case where an arbitrator was asked to interpret and apply the Human Rights Code, even though the collective agreement did not expressly incorporate the Human Rights Code. And what the Supreme Court said there is that arbitrators, at least in Ontario, where there's some provisions in the Labor Relations Act, have that jurisdiction and can and are required to apply the Human Rights Code, even where the collective agreement doesn't expressly incorporate it. What those two cases together mean is that there really isn't any room for litigation about employment rights for unionized employees in the context of pain litigation outside the collective agreement setting, outside the grievance arbitration. And arbitrators have been taking that jurisdiction and applying it. They've begun to apply even the principle of awarding damages for mental distress that are provided for under the Human Rights Code, Section 41. Theoretically, a unionized employee does have the right to launch a complaint to the Human Rights Commission and seek remedy there instead of through the collective agreement. But in practical terms, that right doesn't exist for unionized employees. Section 34 of the Human Rights Code allows the Commission to defer and decline to hear a case where there's an alternative forum for it. And the reality is that the Commission exercises this power in all cases for unionized employees. The only possible exception to that is where there's a complaint against both the employer and the union, and the Commission seems willing to entertain complaints in those settings as well, although they could defer to the Ontario Labour Relations Board with respect to the complaint against the union because of the duty of fair representation. So the primary, I think, difference is that when you're dealing with the unionized setting, you have different parties, the union, and different forum. There are, however, differences between the substantive employment rights of unionized and non-unionized employees. And the real one, the really important one is, at least in this scenario, is that there's some security of tenure for unionized employees that really doesn't exist for non-unionized employees. A non-unionized employee has a right to damages for pay in lieu of reasonable notice if terminated, but does not have a right to reinstatement to employment. A unionized employee does. Collective agreements have just cause clauses, and arbitrators have the power to order employees reinstated to employment. It creates a scenario where a unionized employee has tenure of employment except for situations of just cause, culpable behavior, innocent absenteeism, which Brenda will get into a bit more, where she talks about the duty to accommodate in detail, or in accordance with layoff provisions in the collective agreement where there's a shortage of funds or a shortage of work. Arbitrators in the unionized setting have given great weight to the notion of security of tenure. They routinely reinstate employees who are found to be wrongfully dismissed and improperly laid off to their employment with compensation. They have described this as a fundamental right of the unionized workplace, even going so far on this occasion to describe dismissal in these scenarios as capital punishment in the workplace. That, I think, has fueled arbitrators when they look at accommodation cases, human rights cases, and deal with them. My sense is that arbitrators have been much more sort of robust in terms of the remedies they've developed and applied for employees in the context of accommodation of disability than have even human rights tribunals. Brenda, again, will get into some of the details of the details of the duty to accommodate and what that can mean, but for example, labor arbitrators have held that a unionized employer has to restructure jobs, cobble together duties to create a new position which a disabled employee is capable of performing, and have said that a disabled employee could displace another employee from a position if that's the only position that the disabled employee is capable of performing. The human rights commissions, when looking at these cases, have I think tended to be more, I guess I would describe, deferential to the employer, and have refused reinstatement even in cases where it would be inconvenient to the employer, as one example. So that substantively, I think there's a much greater chance that for the unionized employee versus the non-unionized employee, there's going to be an order that permits the person to continue to work with modifications. It's much more likely that labor arbitrators to award that. Just very briefly, I want to touch on a second topic, which is that there are circumstances in which an employer can actually become liable for the payment of benefits under a long-term disability policy. Most cases, the employer will only be liable to pay the premiums under a plan. But there are scenarios in which the employer actually has to pay the benefits. The non-controversial situations where the employer has self-insured and the collective agreement can incorporate that kind of procedure into it. And I give you an example in the paper of the Ontario government having done that. And that, of course, means that issues about entitlement to benefits are litigated in the arbitration forum. A second instance, which would be more controversial, is where the collective agreement is drafted to impose a specific obligation on the employer. For example, a long-term disability policy that provides a certain level of benefit, and the employer then insures with someone who doesn't provide that level of benefit. In those scenarios, the employer can be held liable for the difference and wind up having to pay the benefits. The third possibility is where, in a wrongful dismissal scenario, either in a unionized or non-unionized scenario, an employee is dismissed and as a result of that loses entitlement or doesn't gain entitlement to long-term disability. And in both the unionized and the non-unionized setting, employers have been held responsible for the damages that flow from that. It gave you the case of Prince and Eaton in the paper, where a non-unionized employee's damages included the loss of the value of long-term disability benefits, which he would have received had he not been wrongfully dismissed, i.e. his injury arose during the notice period. This can have a greater impact in the unionized setting because employees got a right to reinstatement, not just reasonable notice. And so an arbitration case can easily take a year or more. If the employee becomes disabled anytime during that period, there's an argument that she could have got benefits had they not been wrongfully dismissed, and the employer now has to pay. With those comments, I'll turn it over to Brenda to talk more about the substance of the duty to accommodate.
One of the most significant growth areas in employment law litigation concerns the actions taken by employers against employees who are unable to attend work regularly or perform work competently as a result of disability. And this is the type of situation, as I said earlier, where litigation affecting employees with chronic pain or fibromyalgia is likely to arise. And managing attendance has become a very large issue for employers, just simply because of the cost it can have. Chronic fatigue and fibromyalgia are particularly difficult disabilities for employers because of the difficulty in diagnosis in the first instance, and the fact that symptoms can differ from employee to employee, and as well, symptoms don't remain constant but can temporarily exacerbate fluctuate, with the result that the capabilities of the of employees afflicted with these disabilities can change from week to week. This obviously can have an impact on the ability of the employee to perform her or his job competently. Cognitive impairments or pain can result in the employee being less effective decision makers, being unable to prioritize, allowing things to slide to the point of crisis or disaster. And further, absenteeism can mean that the employee can simply not be present at times to perform the work, and that absence can result in backlogs and reduced productivity. This can create problems for employers, as I've said, and often the employer may simply want to dismiss the employee in order to get rid of the problems created by these issues. And if the employer does act, this can lead to litigation by the dismissed employee, either by way of a wrongful dismissal action or a grievance or a human rights complaint. Now, David's already explained the nature of litigation by employees against employers, the nature of the litigation will be dependent upon whether the employee is represented by a union or not. And I'm going to leave to David, if we've got time, to briefly speak on the strategy on the employee's side of litigation. I wanted to speak first from the perspective of defending the employer, because I am convinced that a good defense by the employer in any litigation involving disability must begin long before litigation is begun by the employee. An employer must consider all of its legal obligations at the point that it begins to deal with the employee and the problems that the employee has. In other words, the wise employer will get its defense in place before any litigation ever begins, which usually means that consultation with the employer's counsel should begin early on. First and foremost, the employer must consider the Human Rights Code, and a requirement that employees attend work regularly and perform competently are, of course, both basic terms of the employment contract between the employer and the employee. And the fact is that that requirement can adversely impact employees who suffer from disabilities which preclude them from meeting those requirements. Now, Section 17 of the Code, which deals with disability, does permit discrimination against an employee with a disability where the employee is unable to carry out the essential requirements of his or her job because of the disability. There's a catch, however. Section 17 also imposes a preliminary obligation on employers to first accommodate employees with disabilities to the point of undue hardship before they can discriminate against them by enforcing the requirement to the point of saying to an employee, you can't attend work regularly anymore, I'm going to dismiss you. The Supreme Court of Canada has made clear in cases such as Grismer and Marin, both cases out of British Columbia, that the extent of the employer's obligation to accommodate will be a very high one indeed. The employer will be obliged to consider every possible accommodation, except for those accommodations which would cause the employer undue hardship. And the onus will be on the employer in any litigation to establish that the employer has appropriately considered accommodation and has looked at all of the possibilities. And often the litigation will, in fact, focus on whether the employer has met its obligation to accommodate. The courts and arbitrators and human rights tribunals, however, have established some clear limits on the obligation to accommodate. And these limits are what we look to determine the kinds of defenses that we can raise on behalf of employers to any claim that an action by the employer was discriminatory. Now, I'm not going to take the time, because I know we're running out of time now, to refer you to the case law. That is set out in my paper. But let me just review with you some of the limits that an employer can rely on. First of all, and very importantly, an employer is not obliged to accommodate a disability which the employer is not aware of, unless it's obvious, of course, that the employee is suffering from a disability. Secondly, an employee will be obliged to accommodate. David's already referenced that and the Renault case. This includes producing medical reports, which establish the existence of the disability. It includes producing medical reports which clearly indicate the restrictions, whether the restrictions are physical or cognitive, that arise from the disability. And the refusal of an employee to cooperate can be fatal to his or her claim that he or she was discriminated against. Third, an employee does not have the right to perfect accommodation or the accommodation of his or her choice if the accommodation that the employer proposes is an otherwise reasonable accommodation that meets the employer's needs as well. Of course, the accommodation must respect the dignity of the individual. Fourth, and this relates primarily to the realm of unionized workplaces, employers will be expected to look for other jobs which the employee may be able to do if the employee can't, as a result of the disability, perform his or her own job anymore. And this arises as a result of the security of tenure principle that David referenced. Now, but arbitrators, I can indicate, have made clear that the employer does not have to create a brand new job for the disabled employee, or at least a job that doesn't have some productive value to the organization. I have to tell you that a lot of this is sort of an ebb and flow thing, because different arbitrators say different things, and some of these principles are not yet entirely as clear as we would like. The issue of bumping. Does an employer have to bump an employee out of a job that a disabled employee can do? So far, no arbitrator has actually ordered that this happened. I know that there's a recent case in which an arbitrator sort of thought about in writing the possibility that it might one day, but so far that would be considered by most arbitrators an undue hardship. And while there has been some chipping away at the concept of whether or not the employer, by way of accommodation, has to accept a lower standard of performance, that in other words, do you have to accept incompetence? So far, there's not a case that has actually held that an employer must, by way of accommodation, accept a lower standard of performance. And the Bonner case, the Ontario Human Rights Tribunal case, is still good law on that point. Now, arbitrators have at least recognized that there are situations where accommodation is impossible, where an employee is unable to attend work at all, or so irregularly that the employee is simply not able to effectively hold up his or her side of the employment bargain anymore. And the attendance is interfering with their ability to perform the work. In those situations, arbitrators are still holding that employees can be dismissed from employment. That is where no accommodation is available. Courts as well, in situations where in wrongful dismissal actions dealing with the non-unionized employee, in wrongful dismissal actions where the employer is able to establish that the employee is effectively not able to return to work, is absent, has been absent for a long time, and is not likely ever to be able to return. In those situations, courts will still recognize the principle of frustration, although I think that's a concept that as well is being chipped away at. Otherwise, a dismissal would be proper only with reasonable notice. As for establishing undue hardship, even after all these questions, and I've spoken at a lot of conferences on accommodation, and am still saying, well, it's still foggy, even after all these years. The Human Rights Commission has, as you will know, established guidelines which are not binding as law, and I hasten to point that out, and I also hasten to point out that I'm only aware of 2 decisions in Ontario where decision makers have actually applied the human rights guidelines on undue hardship, the brink of bankruptcy standard that is imposed in considering the cost issue. The Commission does take the position that the only considerations that are to be had in determining whether an undue hardship exists are costs, outside sources of funding, and health and safety issues, if any, which are the criteria listed in our code. As you will know, the Supreme Court of Canada has, of course, enumerated other criteria and have indicated that their list is not exhaustive, but that each case must be considered based on its own circumstances. And this is the approach which most decision makers, certainly arbitrators in Ontario, have followed. And I always like to point out as well that the Commission itself suggests in the case of buildings that it may not, an owner of a building that has been designated as an historical site may face an undue hardship if the historical building has to be in any way impaired, which is not a factor that includes cost. So I think that there's some little recognition by the Human Rights Commission that there may be factors other than cost, outside sources of funding, and health and safety issues. So we don't know what the financial cost is that will amount to an undue hardship. It will either be the Commission's bankruptcy standard, an order for cost to the amount, in an amount that's so significant that it would threaten the viability of the enterprise, or a lesser amount. And the courts have not gone this far. The courts have said that, however, that a substantial expenditure will be expected from employers, and the amount of that expenditure will depend upon the size and the particular circumstances. One thing is clear, however, and this will be very important for employers in defending any discrimination-related claim where accommodation is required, and the employer is saying that the cost is too great, and that's the undue hardship. One thing is very, very clear, and that is that it will be necessary to have very clear, cogent evidence, not based on speculation, but based on probabilities. And by clear, cogent evidence, I mean financial statements, I mean accounting, properly based accounting evidence, and very clear evidence on what the impact of the requirement to spend the monies would be. In a unionized setting, it will be necessary to involve the union as well in the search for accommodation, particularly if the accommodation may require terms of the collective agreement to be waived, and David has already spoken to that. But beyond that, from the employer's perspective, I think it's always a good idea to involve the union and to involve the employee in unionized or non-unionized settings, simply because it's a good thing to be able to tell an arbitrator that you've involved the union. It's a good thing to be able to tell a court or a human rights tribunal that you've involved the employee. And it gives you an indication of it gives the employer an indication of what the employee is viewing as reasonable accommodation. Let me just indicate that the The other thing I guess that should be mentioned is that quite often the employer will face two actions: a human rights complaint and a wrongful dismissal action or a grievance. The Human Rights Commission has now, I think, made clear in the divisional court has upheld the right of the Human Rights Commission to decline under Section 34 to deal with a human rights complaint if there is a grievance dealing with the same complaint under a collective agreement that's going to arbitration. And it is always worthwhile to raise that objection. In connection with the wrongful dismissal action in the courts, however, the Commission will not defer to a wrongful dismissal action, the route that is available, it would appear, is to bring a motion to either stay the action in the court or to even strike out the claim. But the success of that will be dependent on the extent of the overlap between the wrongful dismissal action and the human rights complaint. And if there is not a substantial overlap, the court will not likely grant either of those motions.
Would it be possible to just a minute to comment on one of the points that
Sure.
Brenda made? And that's, Brenda commented from the perspective of, representing the employer, the importance of, getting information involving the union employee. And although we come from different perspectives in terms of who we represent, the advice is actually equally applicable from my perspective to representing the employee and the union, that it's important to make sure that the disclosure happens, that lots of times employees, for various reasons are reluctant to disclose, but it's important to make sure they do and that they request the accommodation early on. I think that it has the same advantages really for the employee and the union who may be later seeking to litigate the issue that it can have for an employer. And hopefully, I guess, really at the bottom line is what it leads to is resolution of the issues and the avoidance of litigation for both parties. Thank you.
Thanks, David. Thanks, Brenda. The next item on our agenda is actually a panel discussion, and maybe as I say their names, they can come up and just find a seat up here. The panel discussion is going to focus on pre-litigation and how to avoid litigation in the disability claims process. I'm going to give each panel member a chance to state their own views for a period of time, and then after each person has spoken, I'll give the other two panel members a chance to ask them a question, if there are any. And then after we've gone through everybody, we'll try to reserve again a bit of time at the end for some questions from the floor. So in terms of our panel members today, we have Rozmin Ramji on my right. Rozmin is a senior claims consultant with Sun Life Assurance Company of Canada. Rozmin has worked in the insurance industry for 25 years and has a number of insurance industry designations, which you can see in her bio. Dean Edgell, on the far left, practices insurance and personal injury litigation in association with Oatley Vigmond in Barrie. Dean has represented many individuals with permanent disabilities, including chronic pain, fibromyalgia, brain injuries, and disabling orthopedic injuries. He's appeared before courts at all levels. He's also the author of a textbook called Product Liability in Canada. And Dean was called to the bar in 1985 and got his law degree from U of T. Dr. Alison Bested is with us today as well. Dr. Bested is a hematological pathologist who was the head of the Division of Hematology and Immunology at the Toronto East General and Orthopedic Hospital for 8 years. Before that, Dr. Bested was also a lecturer at the University of Toronto. She has a special interest in chronic fatigue syndrome, fibromyalgia, and environmental health, and is also a staff physician at the Environmental Health Clinic at Sunnybrook and Women's College Health Sciences Center. So Rozmin, would you start us off with a few comments from your perspective?
I'm going to touch briefly on 3 topics: what information an insurer needs to adjudicate an LTD claim, the adjudication process, and appealing a denial. I can assure you that chronic pain claims pose a significant challenge for insurers, so we need all the help we can get in terms of ensuring that we are provided with comprehensive information. One of the roles of an adjudicator is to analyze the medical information to determine whether the impairment prevents the claimant from performing the essential duties of their own or any occupation, depending on the definition of disability in the relevant contract. At the outset, I want to point out that we do recognize and pay for claims for chronic pain, as well as for chronic fatigue syndrome and fibromyalgia. However, the diagnosis alone is not sufficient. So what else do we need? First, we need the nature and severity of the symptoms and what impact they have on your ability to function. Secondly, the restrictions and limitations imposed by the condition. Example, how long are you able to sit, stand, walk before you need to stop and rest? Or you can provide an outline of your tolerances for certain activities, such as lifting, carrying, bending, driving, especially as they relate to your job. We need a detailed job description or physical demands analysis. We need an outline of your education, training, and experience. Results of tests performed, including consultation reports from specialists. And finally, provide details of the treatment program and your response to treatment. Include a list of medications prescribed, whether you have tried any kind of therapy, such as massage therapy, acupuncture, psychological counseling, or CBT, which is cognitive behavior therapy. The adjudication process. Claims adjudication is a multifaceted process. Once we have gathered the medical and functional information, we review the job description or an outline of the essential duties of the job. At the same time, we have to be cognizant of any contractual provisions and limitations that may apply. We may decide to refer the file to our medical consultant for an opinion. If there is conflicting medical evidence, we may consider an independent medical assessment or an FAE in order to arrive at a final conclusion. Another tool we can use is surveillance, which is effective in either confirming the claimed activity level, or it may show that the claimant is really capable of doing a lot more than they're letting on. Finally, it may be appropriate to have a rehab consultant involved in a file if it appears that there is some opportunity or the claimant has expressed an interest in attempting to resume a modified return to work plan, or that they want to consider retraining to a more sedentary occupation. The rehab consultant typically does a home visit and completes a rating of the rehab potential for that case and can coordinate a potential return to work with the treating doctor's blessing. Also, they can suggest an ergonomic assessment if required. In terms of appealing a denied claim, the first thing is to submit the appeal as soon after the denial as possible. Don't wait 9 months to file the appeal. If it is filed late, it prejudices the insurer's ability to fairly adjudicate the claim and to conduct investigations or assist with rehab. Always include new and updated information with your appeal. For example, consultation reports from any specialists, clinical notes and records from treating doctors, treatment at a pain clinic or a sleep clinic, results of any tribunal hearings, i.e. CPP, WSIB, or other provincial tribunal hearings that may have heard your case and documented their findings. Provide a detailed outline of how the condition affects your activities of daily living, and finally, what strategies you have in place to cope with the pain and limitations. Thank you.
Thanks, Rozmin. Dean or Dr. Bested, first of all, do either of you have any questions for Rozmin, just in terms of follow-up? Or
Can I have more money?
going to be easier on her today, are you, Dean? Or yes?
No.
Does that apply to me too, John?
No, definitely not you. Okay, well, Dean, do you want to?
I'm going to stand to do this, and I'm going to try to keep myself wired here. There. I like to stand because I stand in court. I'm a litigation lawyer, and so I like to go to court and I like to litigate. but it may not always be the best thing for my client. And so part of my job is to look for alternatives. And that means settlement, and settlement means negotiation. And so if you'll bear with me, I'm going to go off on an academic tangent and talk about negotiation as a concept and as a process without speaking immediately about chronic pain or disability. And much of what I'm going to say comes from the Harvard Negotiation Project and this wonderful little book, Getting to Yes. It's my promotion. And when we talked about the theory, we'll come back to applying that theory to disability claims. Should work. All right, there we go. The Harvard Negotiation Project tells us that the reason we're negotiating is to produce something better than what we can do without negotiating. If we can't get something better, we shouldn't be negotiating. We shouldn't conclude an agreement. So the first step in any negotiation is to consider what results you can achieve without negotiating. What is the best option you have here besides the negotiated agreement? And they call that the best alternative to a negotiated agreement, or a BATNA, and I'm going to use their terminology. Your BATNA is the key to everything. What is my best option besides agreeing with Rozmin or with someone else? You have to measure any proposed agreement against your BATNA. That's how you determine whether it's a good deal or a bad deal. If I can do better on my own without your agreement, I should go on my own. If I can't, it's probably a good deal for me. And if you haven't thought about what you can achieve or what you will do if you don't make an agreement, then you're negotiating without any means of measuring things. Your eyes are closed to what your options are, and your eyes are closed to determine whether it's a good deal or a bad deal. You are grabbing at something blindly. So it's very, very important for us to think about where we're going to go if we don't make a deal. Now here's a man who does not know what his alternatives are to the negotiated agreement. And he is dealing with a consummate negotiator, Dogbert, the car salesman. That's what happens when you go in determined to make a deal, but not thinking about what your options are. The other thing we know is that the better your alternatives are, the greater your power is in that negotiation. If I have good options, strong options, I don't have to make a deal. And I don't have to make a deal unless it's better than my options, and that means you're in a position to force a better deal or to walk away from a bad one. Now, having considered your options and come up with your BATNA, do you tell the other side what your BATNA is? Well, sometimes. If you've got a really good one, you tell them, I have such a good option here that you're going to have to match and beat my offer, or my position, my alternative, or I won't go into a deal. On the other hand, if your best option is horrible, then you may not want them to know that, because it means they can offer you less and you'll be more likely to accept what would otherwise be an unattractive agreement. Now this leads us to the understanding that we have to work to improve our BATNA. If we improve our BATNA, we have a better negotiating position so that we can get a better deal. Even if we want to settle, we should work on our alternatives. And so the Harvard Negotiation Project tells us we should convert our resources, the resources we have, which are knowledge, time, money, people, connections, our wits, everything should be done to create the best possible alternative to settlement. And that will, in fact, assist us in getting a better settlement. We should also consider the other side's position. What are their alternatives? It's important to know that, because if their alternatives are so good that they don't have to give you what you need, you're never going to make a deal. And you might as well know that up front. The other thing is, if they are misunderstanding their alternatives, if they think they've got great alternatives, you need to change their perceptions of them, or you need to change their alternatives. You can educate them, explain to them why they're wrong about their alternatives. If they think going to trial is a great idea, maybe you want to explain to them why it's not a great idea for them. Or you could change their alternatives, if you're able to. If they think the trial's going to be a cakewalk, again, you make sure that it's not. And here is Dogbert, once again, my negotiating hero, changing the BATNA of the people he expects to negotiate with in the future. Another example that is given by the authors of this book is about a man who is negotiating with his son to get his lawn mowed. He wants his son to negotiate wants to negotiate so his son will cut the grass, and he is offering him large sums of money to cut the grass, and his son refuses persistently. No amount is enough to get his son to cut the lawn. And then he realizes, because his son makes a mistake in the negotiation, and tells him why. Why is no amount enough? Because, Dad, you leave your wallet on the dresser every Saturday and I get what I want without cutting the lawn. So his alternative was, I get the money anyway, why should I do the work? But Dad is then able, with that knowledge, having considered the other side's BATNA, to alter their BATNA by A, taking his wallet off this dresser, and B, explaining to his son stressfully why he shouldn't remove money from his father's wallet. Changing the BATNA leads to a successful agreement. Now I want to apply these principles to disability benefit disputes. What is our BATNA? Well, we could just give it up and walk away, or we can go to trial. So the strength of our case, I'm going to presume it's good enough to go to trial, is the measure of our BATNA. If I've got a good case, I've got a good BATNA. If I've got a good case, I'm in a good negotiating position. If you have a good case, it's easier to settle on good terms. If we improve our case, we've got a better BATNA, we have a better chance of settling on good terms. So the principle is, work on your case. Build your case for trial in order to settle your case. So, if you've got a good case, you're better prepared for litigation, you're better prepared for trial. That's a good thing. But you're also more likely to settle. One of my mentors early in my career kept saying, it's so easy to settle the good cases and so hard to settle the bad ones. And he wanted to take the good ones to trial. But it didn't work that way, and it never really does. And that's my point, that preparing for trial is preparing for settlement. So I'm going to talk for a minute about preparing your case, but I'm going to fly through pretty quickly because you're going to get it again and again and again. You've got some of it from Rozmin. You're going to get some of it this afternoon. You need to get a copy of the policy. What are we talking about? What is the coverage? You need to identify the information necessary to establish how much money you're entitled to. You need to establish what the job is, what are the duties, so you can compare that to the disability. Job descriptions from the employer. Visual evidence of the job can be very useful. I've had a couple of cases where I had actual films of people doing the job, and it is so much more effective to say, here is what they have to do, and this is somebody lifting the things they have to lift and bending the way they have to bend, than it is to simply try to describe it. One of my colleagues had a great case involving someone working in a donut shop. And everyone kept saying, well, it's just a donut shop, it's just a donut shop. And then they had photographs of them bending over and reaching in and pulling the baskets out and moving things around, and how much bending and lifting and hustling was required to do that job, and it changed the whole case. You want to look at previous occupations, if there's an any occupation clause. You want to get medical reports, obviously. It's very helpful if the doctors know what the duties of the occupation are before they express an opinion on whether they can do it or not. Far too often they just dash off something without considering the disability in the context of the job. And you might look at other sources of information, such as surveillance or talking to people who work on the job or might know the claimant, and consider getting expert assessments from people you rely on. Settlement means sharing information. How do you affect their BATNA? How do you disclose our BATNA? You have to share this information. If you don't show them your case is strong, you haven't affected their perception of their BATNA. And if you show them, though, that there's significant persuasive evidence, and that demonstrates that you are prepared to go to trial and that you will be successful at trial, then the other side is going to be finding litigation unattractive, and they'll look for alternatives, more attractive things such as settling. It is important to recognize, particularly with people with these kinds of disabilities, that you can't always know what your alternative is. When someone comes into my office and introduces themselves to me and tells me their problems, I cannot know right away how long their disability is going to last, how much money they're entitled to, how long they'll be entitled to it. If you don't know your BATNA, you're negotiating blind. So sometimes it's just wrong to talk about settlement too soon. You can't go until you really understand what your BATNA is. So my rule is, until I can assess the disability with a degree of confidence, including its duration, I can't assess my BATNA, and I'm not prepared to go into negotiation. And sometimes the best thing you can do is can carry on with the litigation, continue to build your case until the prognosis is clear, the probabilities of result of trial are clear, and my BATNA is clear. And then I'm ready to negotiate. You should continue to review your BATNA from time to time because cases change as information comes in, and you want to always know what it is in case the opportunity for settlement arises. I'm going to close once more with my hero, Dogbert, who sees that his alternative is not going to be good. The trial is going badly. It's time to consider options. Now, whether that's a good deal or not depends on whether or not he thinks he can do better without making a deal. Thank you very much.
Why don't I just pause my...
Just 1 second. You throw that up to turn it on.
There, am I on now? Okay, great. Okay. It's a pleasure to be here to speak with you all on this lovely spring day. I'm here to present the new clinical definition of chronic fatigue syndrome. And it was written basically by an international expert panel of physicians. There were 11 of us in all. I was one of them. I was fortunate to be invited. And it was developed as a result of a problem with the chronic fatigue syndrome, and that the definition, the research definitions, am I kind of bouncing back a bit? Maybe I should put it down just a little bit. Is that better? Okay. So the problem was that the research definitions really didn't encompass all of the clinical complexity that is present with chronic fatigue syndrome. So we were asked to get together by the Ministry of Health, and there were 11 physicians worldwide, and we represented a total of 20,000 patients that the total of us had treated before coming together. So the new definition, I can figure out how to put this on. Is it on? Okay, good. So I hope that's straight. So this is a new myalgic encephalomyelitis, and that's the British term that has been used for chronic fatigue syndrome. Myalgic means inflammation of the muscles. Encephalomyelitis means inflammation of the brain. This is more of a pathological descriptive term describing parts of the illness. Chronic fatigue syndrome is more the North American term that's chronically being used. And it's a clinical working case definition, the diagnosis and treatment protocols. The prevalence of this is, as you've seen previously, it's very common. 25% of all patients that present in a general practice to a general practitioner report fatigue as the first and foremost symptom that they go there. Chronic fatigue syndrome affects all ages, races, and ethnic groups. And the actual statistics for the chronic fatigue syndrome, based on a huge sampling by Jason in Chicago, they interviewed 28,000 patients, found that there were 522 women and 291 men per 100,000. That's a huge amount compared to AIDS, which is 12 per 100,000. And as you can see, fibromyalgia is right up there with heart disease at 3,400. So these are not uncommon illnesses. They're very common. Just another perspective comparing other things. Breast cancer, lung cancer, diabetes, hypertension, heart disease. So further perspective, if you look at Toronto, City of Toronto and the GTA, population of 4 million people, 54,000 people, women meet the criteria, 8,000 men meet the criteria for fibromyalgia, 12,000 individuals meet the criteria for chronic fatigue syndrome. So you can see we have a whole city of people within the city that are severely disabled. So chronic fatigue syndrome in particular emerges as a serious women's health concern, and so does fibromyalgia. These are old statistics, and unfortunately part of the problem in Canada is that we don't have a diagnostic definition in the billing fee code at the moment, so we really can't do any accurate assessments based on our OHIP fee code. So these are just based on general costs for fibromyalgia, which there is a billing fee code. So in 1993, the average cost per OHIP per general patient was about $536 per year. The average cost to OHIP for fibromyalgia was $1,028. So it's a huge amount that's going into these conditions. And we talked about the impact of making the diagnosis. Is the diagnosis being made helpful? It is the most important thing from a patient's perspective. An average of 5 to 7 years often elapses before the diagnosis of fibromyalgia is made. 70% of GPs are reluctant to make the diagnosis of chronic fatigue syndrome, and the reason for that is it was not taught in medical school. It's only been in the books since 1984. The new definition's just been printed in 2003. So part of the problem, it's an educational problem. So the information has to be dissipated to all the treating clinicians in the world so that we have some idea of what we're dealing with. Almost 90% of the patients believed that the definition of chronic fatigue syndrome was the most helpful factor in managing the illness. This is because it validates that they have a problem, you've seen it before, and you know what to do with it. So if you can validate the person, this is the most important step in terms of treatment. I'm just going to review briefly, because we've talked a lot about definitions and how is this different from the previous definitions, which were the research definitions. This is a clinical definition, and the reason it's different is because it encompasses the complexity of the illness. This illness affects every organ system in the body. So to go off with it, it has fatigue, it has post-exertional malaise and fatigue, sleep disturbance, pain, we've already spoken to those. It has neurological manifestations, and it also has autonomic, neuroendocrine, and immune manifestations. Just a word about the fatigue. As mentioned previously, this fatigue is not, gee, I'm tired, I think I'll have a cup of coffee kind of fatigue. This is the fatigue that if a person exerts himself by going for a 10-minute walk, if it's more than what their body has energy for, they may end up in bed for 1 day, 2 days, 3 days, depending on the severity of their fatigue. So this is incapacitating fatigue. So the word fatigue is a very difficult word to deal with. Your fatigue is not my fatigue, and it's certainly not this patient's population. This is debilitating fatigue. The pathophysiology. This is a theoretical model, and there are several out there. And one is that there is some sort of a virus or some sort of an infectious agent. It causes the body to release cytokines or tissue necrosis factor. This has an immune reaction. It causes increased messenger RNase L. And what happens is that this messenger RNase L, normally if there's a virus, it's like a Pac-Man. You basically have a virus, the Pac-Man comes along, chews it up, and then the whole system gets turned off in a negative feedback loop. But what happens in this illness is that this Pac-Man, like enzyme, messenger RNase L, it keeps on chewing. It's like the Energizer Buddy. It keeps on chewing. And what does it chew? It ends up chewing cell membranes. The cell membranes are like the walls that sort of let the enzymes, and it lets different biochemical things like potassium, sodium in and outside the wall. So these are the things that regulate what goes in and outside the wall. And they think that there's an abnormal protein that gets stuck in the cell membrane structure. And it starts to replace ankyrin, which is a cytoskeleton filament. And what happens is that the normal cell membrane activity that keeps certain things in and keeps certain things out gets distorted, so the cells start to leak. And where they leak, the cells are damaged. And depending on where the damage is in the body, results in the specific symptoms. So if you have problems with this cell membrane problem in the brain, you get problems with cognitive functioning. There is a reduced executive functioning, difficulty attending to details, difficulty with short-term memory, difficulty with sleep. If you have the problems in the muscles, you get pain, fibromyalgia kind of pain. If you have difficulties in the gut, you have irritable bowel type symptoms. And they have actually shown some of these studies on very elegant tissue biopsies showing that they've done monoclonal antibodies, and they've shown the uptake of this abnormal molecule in the cell membrane. So this is still a theoretical model, but I think it certainly puts us out of, is this a real illness? This is legitimate. You just can't get over the fact that these people, you can see this on the tissue in the different parts of the body that have been biopsied. Fibromyalgia can be a component of the illness or not. Some people with chronic fatigue syndrome have severe muscle pain. Some people do not, and I think this has already been eloquently addressed. The treatment goals for the chronic fatigue syndrome and also the fibromyalgia, is to optimize the patient's ability to function, to keep them as active possible within their boundaries initially, so that they understand where they are at, and they understand that they do have physical limitations and that they need to slowly expand those boundaries. This involves a lot of education. The patients have to be educated about their illness. They have to be taught the early warning signs of their illness. So if a patient does not pay attention to their body, and if they don't pay attention to the fact that when they do too much walking or they go to the grocery store for too long, that they get this sore throat, and then they basically continue to ignore it, and they ignore the sweaty palms because they've basically been stressing their body, which is a stress reaction. If they continue to ignore their body, they will end up in bed for 1 to 3 days or longer. So the important part is to learn energy conservation so that they learn where their boundaries are, but to learn to maximize that so they stop crashing. So what they need to be taught is basically how to avoid this crashing pattern. This is where they push themselves and they do too much and they crash, and push themselves and too much and they crash. And unfortunately, in my patient population, I have a few patients that have done this, and they are the most highly motivated bunch of people, and basically they've ended up full-time in bed, unfortunately. So the trick now is how to remobilize them after they have been totally bedridden. And what you do is you get them exactly like Dr. Abbey says. You start, if you can walk to the bathroom, okay, once. Can you walk to the bathroom plus 2 steps? Can you walk to the bathroom twice? And how do you extend those boundaries out slowly? But it's a very individualized program because these patients are so dramatically different one from the other. This is another thing that we use. It's called an activity log. And this represents normal. Across the top are the days of the week, and down the side are the hours of the day. And at the bottom are rating scales. This is a color coded just for your information. The yellow represents activity. This is what most of us are like. We can get up in the morning, we go all day long, and we don't stop. This is what normal represents. And we can also pull an all-nighter, which all of us do occasionally for various reasons, and we can get up and go to work the next morning. And this is normal. Some people are even better than normal. They require 4 hours of sleep a night, and I'm sure Dr. Appleton would love to have done a sleep study on Margaret Thatcher, because she's just a very unusual lady, and she just sticks up like a wonderful, how does she mobilize this energy to be able to perform after only having 4 hours of sleep every night? And this is what she did. So she's a very high energy level person. So on average, people range between 9 to 10 out of level energy ratings, and the rating scale that's used is 0 to 10. So 9 to 10 is considered normal, and this would be considered a normal daily activity. You can go all day long, you can exercise for at least an hour, 3 days a week, and you can be up for 16 hours a day. That's what normal is. This is more typical of what chronic fatigue syndrome is in the patients that I am seeing. The blue represents the times required for rest. So as you can see, they're severely compromised. They have difficulty getting up in the morning. And the yellow would represent areas of activity. They could actually go out, go to a few doctor's appointments, perhaps go grocery shopping. And the orange would represent low-level sedentary activities, things like lying down to either meditate or to watch a TV show or possibly listen to a program. Possibly read if they had the cognitive ability to remember what they were being read. And the energy levels rate often between 3 to 5 out of 10, so they're extremely low. And in your handout, there is a functional capacity scale there for you to look at. And this was devised by myself and Dr. Marshall. And the reason we came up with this is because fatigue is such a nebulous term, and the patients would describe their fatigue, and we really didn't know what they could do or what they couldn't do. So we came up with this as a help for us to be able to see not how they felt, but what could they do. So it describes in terms of, can they do a bit of laundry? How many minutes can they walk? Just exactly what are their functioning levels? And as you can see from the scale, like 1 is kind of ICU kind of patient, and then you go up to the scale gradually. But people, again, they're really not normal until they're about a 9 out of 10. So there's a great variation in the degree of what people can do. And the lower end of the scale, obviously, people need a bed bath, assessment by home care, and at the upper end, they're much more mobile and starting to regroup and starting to mobilize. So the idea is to try to get them to improve gradually and hopefully see the numbers go up the scale. So one of the things, obviously, that they have to do is one of the most important things, in my opinion, is to get them sleeping properly, because if they don't have restorative sleep, they don't heal. So Dr. Appleton's already addressed a lot of these things already. The other thing that they need to do is, pretty basic stuff, but it's eating. Some of these people are just too tired to eat. They cannot get themselves up and make themselves a meal. Making themselves a bowl of soup is a major gargantuan effort. So they may have to have Meals on Wheels come in, or somebody actually to come in and prepare the meals for them, depending on where they're at. And this is just obvious good nutritional counseling. In terms of mobility and exercise, absolutely, they have to stay as mobile as possible, but the idea is to do it without crashing. They have to increase slowly, and I usually suggest the 10% rule. So if somebody can walk for 10 minutes and they feel like they're getting a little better and that you want them to encourage them to move forward, you encourage them to do it slowly. Add 1 minute. And it's not 1 minute a week, it's 1 minute as they can do it. And slowly, so it's very individual. And there have been studies that show if you push a person too far, exercise-wise, that they do physically crash. And that is in the literature. In terms of strength training, that also helps, and you also want to prevent osteoporosis in these people. They're sitting ducks because they are so immobile. So you want to basically, as soon as you can, get them doing some strength exercises. Even when they're in bed, they can start to do some of these things slowly. And you need to obviously stretch and strengthen for fibromyalgia. I just want to say a minute about pain as well. There is this is called the Evidence-Based Recommendations for the Medical Management of Chronic Non-Malignant Pain. This has been put out as a reference guide for clinicians from November of 2000 from the College of Physicians and Surgeons of Ontario. And the reason it was put out was because fibromyalgia is a poorly understood illness in terms of etiology, but certainly it does respond well to pain management. And there's a variety of different things you can treat these patients with, including just getting them up, walking, stretching, acupuncture, massage therapy, aquatherapy, etc. But one of the things is the use of medications, including narcotics. And most clinicians are very reluctant to start people on narcotics. It's kind of almost a big taboo, especially if there's not a cancer or some obvious lesion that's there. So this document basically supports the idea that if you do have a chronic non-malignant pain, of which fibromyalgia or some of the patients with chronic fatigue syndrome have, it's important to get these people treated. Why? Because you can get them up, get them going. If you attend to their pain, you get them more mobile, they have a better quality of life. So it's important to do that. In terms of the psychological support, it's important to help people deal with their chronic illness, and basically they have to deal with denial, because a lot of them don't want to be sick. In fact, I haven't met anybody yet that wants to be sick. Have you met anybody who wants to be sick? I haven't. And they have to grieve their loss. They've lost their job, they've lost their health, they've lost all the goodies in their life, and they have to learn to basically move on. And this is a very difficult process for them. And it takes a lot of intense work on the behalf of the patient. So one of the things that they get stuck at is denial. And using the activity logs and showing the people how they have progressed is helpful. And it also shows them the parts of the day that they're mastering and they're doing great, so that they can continue to increase what they're doing. Cognitive behavioral therapy also helps in terms of helping the patient to cope with chronic illness and the stress of being chronically ill, the stress of having a reduced income, the stress of being cut off their insurance disabilities, the stress of having people deny that they have an illness because they look so well. So it's an important tool, but unfortunately it doesn't make them totally better. In fact, it helps them to cope with the illness, in my opinion, but it doesn't attend to the fact that it's not going to make them better. Their fatigue does not improve. And I've been doing cognitive behavioral therapy now with a psychiatrist the last few years, and I wish I could say, I was hoping at the beginning that the fatigue would improve, but unfortunately I have not seen that in my own practice. And we've treated a number of patients now. In terms of assessing the disability, as a physician, you need to explain how the patient's symptoms impose specific functional limitations to that patient being able to work. For example, the patient, again, is not disabled by their disease. You can have fibromyalgia and work. Pain can be mild, moderate, severely disabling. Chronic fatigue syndrome can be mild, moderate, or severe. So it's not the diagnosis that's a disability. It's how does it impact on the patient. Again, this is where the activity scales of some sort are helpful, or some sort of a tool, because it shows you how fatigued they are. Can they get up and make themselves a bowl of soup? Do they have to rest after they walk for 20 minutes for half a day? Can they get up and walk to the store? Like, where are they at functionally wise? Can they read a paper and remember what they've read? Can they do their bills? They have to, most people these days have to have a high degree of executive functioning, which includes a good short-term memory. It includes being able to multitask. It includes being able to synthesize. And a lot of these functionings are unfortunately impaired, and this has been shown on the neurocognitive testing, which would be wonderful if we could get everybody to have one of these tests done. But unfortunately, in our current system, OHIP has cut back on this. So the neurocognitive assessments now cost on average about $2,000. Also, the physician has to figure out from his perspective, especially it's helpful if the GP is involved because they've known this patient for a long time. They've seen the patient before the illness. Usually these people are high functioning, they work a full-time job, have families, exercise. The common story that I hear most often is, there were 20 of us at the Christmas party, I was working full-time, enjoyed my job, et cetera, et cetera. 10 people got the flu, I got this. So it's a common thread of flu-like illness that seems to present in a majority of these people. So what you need to determine is the prognosis, and basically all you can do is base that on the information you have when you see that patient. So your prognosis is based on what are you seeing, how has the person been doing for the last 6 months that you've been seeing them? Are they getting dramatically better? And some do. But are they basically not making any gains at all? You report what your findings are. The rehabilitation potential, again, most of these patients that I'm seeing, unfortunately, are the most severe group. The patients that the general practitioners see are much more mildly. Because I'm a specialist, I sort of see the worst case scenario. But the general practitioners often, if the diagnosis is made early and these people are properly treated, they have a great potential to get back to work, in my opinion. And so part of my goal is to basically educate enough people so they will get an early diagnosis, so their potential to return to work will be greatly enhanced. So what tools do you have to help assess these people? Well, obviously, as a clinician, you use your patient interview tools. We've talked about those. There are formal questionnaires, sickness impact profiles, Karnofsky performance scales, medical outcome short study performance health surveys. A lot of these are not available to the general practitioners. Okay, these are more sort of studied related areas, but they can be used. And I think we need to develop more of these tools for the general practitioner. Then there are symptom survey scales that are helpful. Look at the patient's symptoms. How severe are they? Cognitive dysfunction. What can the patient do? Can they pay their bills? Can't they concentrate? Can they add things? Describe what the patient's like during the interview. Using patient diaries, activity logs, and sleep and pain diaries. These are all helpful tools. The other thing I was asked to address was in my chat, if you want to look at the back page of it. So what can the lawyer expect, basically, from a physician? And I think you can expect the following in the report: the diagnosis, the summary of the history, physical findings. You need to record, the physician needs to record the dates that the patient was first seen, how often they're being seen. A description of the patient's function before the illness, if you've known the patient before, is very helpful, because then you can see the difference before and after and the impact of the illness on the patient. The long-term prognosis based on your current information. Doctors are not mind readers. If you don't know, I think you have to say you just don't know. And I think it's better to be honest to say you don't know than say, gee, I think this person will be able to improve in 3 months. How do you know that? I think it's best to say the patient in the last 6 months has made some improvement, no improvement, or they've retrogressed. But I think your information should be based on your clinical findings. The degree of disability, it's helpful if you are supplied with the actual legal definitions in the insurance contract that you're asked to comment upon, because sometimes I get asked to comment on this and I don't know what definition is being used, so that's very helpful if you can supply that. The physician needs to comment on the reliability of the patient, the motivation to get well. Most of these patients, they get into trouble because they're the opposite of depressed patients, in the sense that depressed patients are they're not motivated. They have difficulty getting going. These patients, they push themselves to the point of crashing, and they push themselves to the point of crashing. So the problem with these people is to figure out how to smooth out their days so that they get that crash information or that crash energy and they promote it towards healing. So these patients are really different than depressed patients. Not to say that these patients can't become depressed. Absolutely they can. And it's a reaction to becoming chronically ill. So that's another part that you have to help these patients deal with. But again, in terms of motivation, most of these patients are highly motivated to improve their situation. Often, if you require the chart, ask, tell them what part of the chart you want. Do you want just the lab findings? Do you want the whole clinical notes? Be specific. And also, it's helpful if you let them know when the information is needed by. We're all overloaded, and I know you are, and I'm sure, and I am too. So if you could say, look, I really need this information by this date, it's very helpful. And if there is a billing expectation, you should lay it out, what the billing is expected for it. If court is coming up and the physician is involved in court, you have to educate the doctors, because we don't get a lot of this in medical school. This is part of the problem. You have to educate the doctors what is the expectation. So if court is necessary, you'll have to explain what the process is, what the doctor is expected to do, and because most doctors have not been to court, they don't know the process. So I think this is the challenge from the lawyer's perspective, is how do you basically tell the doctor what the expectation is in terms of time commitment, and also financial details. Is there a financial, is there a payment method, or how is this done? So a lot of these things are just not known. So I think you have to really clue the physicians in. So in summary, I hope that's been helpful for you. And I think that overall chronic fatigue syndrome and fibromyalgia, we've improved dramatically from where I started in the field over 10 years ago. And I think that there is a much better understanding. And hopefully, as we get an actual laboratory test that is on the way, hopefully that will make things a little bit simpler. But I think in terms of disability, there's a wide spectrum in both of these illnesses. People can be not disabled at all, or they can be mild, moderate, or severely disabled. And I think this is the complexity of it. Thank you very much.
Thanks very much, Dr. Bested. Unfortunately, we've pretty much run out of time, but just if anybody in Toronto here has one question, a quick question. Does anybody have a quick question for this group? No? Okay. Well, we'll break for lunch and come back at around 1:30. Thanks.
Thanks, ladies and gentlemen. We're going to be back promptly at 1:30, and we'll begin at that time with what I think will be a dynamic panel on the tactics and strategies applied by plaintiff and defense counsel in litigating these cases.